through these checks of theirs, they made the voice of the public heard so that what could be corrected was corrected. NGOs have the same role today as well. However, I believe, at least on the basis of the reports that I'm seeing, even if mistakes are made, they see them as individual mistakes, not system-based mistakes. So there are mistakes and errors that are made, but I believe that cooperation with them has not come to a standstill. On the contrary, it is still needed. And how? There is another thing that I wanted to say, and that is the new legal framework that makes it possible for us to correct the mistakes that we made in the early 1990s and the trials that took place then in absentia. Now it is the state prosecutor's office that is a party in the proceedings, and they can launch an initiative of their own for retrial if they believe that there were violations in terms of one's legal right to defense, or if they believe that the proceedings were not carried out appropriately. I'm sure that Mr. Bajic, my colleague, is going to speak about that. It's not that we really discussed it beforehand, but I'm sure that he's going to provide some specific information about this. Last year, we started these proceedings. Some have already been completed. Others are in the stage of investigation, whereas in some cases, the state prosecutor's office has simply given up on prosecution in particular cases. But the important thing is to apply what we have available now, and in this way we can correct the injustices that may have occurred. However, I have to repeat this once again, victims expect us as courts to speak for them through the language of justice. Not a single victim should remain silent, as it were, without receiving satisfaction from the courts. I would like to end on this note, and perhaps we should hear the prosecutors at this stage.
Thank you very much, President. You have very much insisted on the independence of judges, the impartiality, independence, and seen to be independent. I think that's very important. Where you speak for judges, and your colleagues said the same thing, where for judges independence is very, very important. I think for prosecutors, and my colleagues will probably agree, for us it's interdependence. Interdependence between the colleagues here present, and interdependence with the OTP in The Hague. So perhaps I would start with colleague Barashin, if he could, in 2 minutes, explain what his main challenges are. Everybody has spoken about your office. We all know that an important part of the burden of future cases are on your shoulders. So how do you assess cooperation today with your colleagues and our office? But mainly, what are your challenges? Where can the international community support you?
Good afternoon, and thank you for giving me the floor. Let me just tell you that it is difficult to speak about these problems and issues in front of such a large audience and amongst my colleagues with whom I'm nearly in contact on a daily basis. The Bosnia-Herzegovina Prosecutor's Office and prosecutors started their work when we didn't have any premises, we didn't have anything. However, now this is a modern institution which is closely cooperating with the ICTY Office of the Prosecutor, as well as with the offices of prosecutors in the region and further afield. Our cooperation with the ICTY OTP, in my view, is excellent, although it does not necessarily mean that it cannot be improved. The ICTY OTP, ever since a special war crimes department in the court of Bosnia-Herzegovina has been established, maintained cooperation with us. They helped us to organize and to establish this special department. and they helped us with the referral of cases and the deferral and referral of cases from Category 2. There were 11 cases under 92 bis, and all of these cases have been completed by the BH court. There were about 30 cases of Category 2, which involves the cases where investigations are still ongoing and no indictments were issued. We maintain and will continue to maintain contacts with our colleagues from the ICTY OTP. We discuss things and we have adopted certain experience, although it is hard to take experience by someone who is not willing to listen and learn. We did listen and learn. We took the best part of their experiences. However, we never gave up on our culture and our legal system. Since 2003, and you all know that very well, we have had an adversarial system in which we have a new role of the prosecutor. He is conducting investigation, issuing an indictment, and providing a case. This is, as you said, a kind of hybrid combination between the international and national systems. Whether this is in compliance with the Constitution, whether that is undermining the sovereignty of Bosnia and Herzegovina, is something that I have my own opinion about. Irrespective of the fact that we have international colleagues there, my opinion is that we haven't lost anything in terms of our sovereignty. Quite the contrary, we have gained from the experience and expertise of our colleagues who worked in different systems, who had worked in the ICTY, and we adopted their knowledge. Of course, there were clashes. It is only natural that if you have two juries, there are three interpretations of one issue. However, we never did resort to compromises. We sought solutions, and that resulted in the number of indictments and the number of people tried for war crimes. There are differences of opinions, because many will say that we didn't do anything. However, in this war, Bosnia and Herzegovina saw the most of war crimes. This is our reality, and that is what has happened. But we have to get out of this. I am speaking now a little bit like a politician, but I am a professional prosecutor, and my desire is to try and punish everyone who has committed a war crime. Just like my learned friend Horvatin from Croatia said, all the war crimes enshrined in Chapter 17 of the law in Bosnia and Herzegovina are called war crimes. Our colleagues from the ICTY, after the referral of cases, have launched certain projects in order to improve cooperation. We have a liaison officer in the Hague Tribunal, and he is helping us on a daily basis. He has access to public databases, and he's providing us with necessary evidence. This was a step forward, and that made us effective and efficient in our own investigation. A role of a prosecutor in Bosnia and Herzegovina is very specific, and the role of a judge is even more specific, because in Bosnia and Herzegovina, everybody blames the prosecutor because no one is willing to cast a realistic look on the situation in which the prosecutor finds him or herself and what he can do within the law. And he is extremely being watched and monitored by judges. Even during the war, we started working on the laws in Bosnia and Herzegovina. I worked as a county prosecutor, and I dealt with war crime cases when a different system was in place. We have now transferred to a different system which requires abundance of material evidence and witnesses. However, one specific feature of the system in Bosnia and Herzegovina are the witnesses. The passage of time has its impact, and for that reason we have to be more efficient, we have to conduct more investigations and bring more trials to a closure. And for that purpose we need more prosecutors. The Prosecutors' Council at its last session has advertised posts for new prosecutors in Bosnia and Herzegovina, and at least 5 new prosecutors will be assigned to deal with war crimes. We have very many specific issues, and there are so many questions that I can discuss with you for a couple of days that are related to Bosnia and Herzegovina. One specific feature of Bosnia and Herzegovina is the state strategy that is applied on war crime cases. The Council of Ministers of Bosnia and Herzegovina, at the proposal of a working group, adopted it last year on the 29th of December, and its implementation is underway. However, I think that if this is going slowly, we have certain deadlines to meet. I may have didn't address particularly the issue mentioned by my colleague Bramertz, but I would like to say that the presence of internationals in the war crime court in Bosnia and Herzegovina is very important, and that has given a new dimension to the whole process. Bosnia and Herzegovina is a very specific state, different from any others, and based on that and due to that, we have to be more effective in trying to solve all our problems. That is what I would like to say at the beginning.
Thank you, colleague Barashin. Indeed, the number of issues you have mentioned and the challenges you are speaking about could easily be the topic of a full conference. Unfortunately, we have not this time, and time is running. Thank you very much for your comments. Colleague Bajic, we have said cooperation is a very important issue. You, together with the 2 colleagues here present, you have taken the lead on working on a number of projects. The Brioni process, which is known to all of us, being a meeting of prosecutors where we are all coming together. And the European Union, my colleague Norman Farrell this morning, or myself, we have always mentioned these projects of liaison prosecutors being a very, very efficient one. But this is one of the projects coming from the colleagues through the bottom-up approach, where it was a suggestion made by the colleagues on one of those meetings, which was made exactly 2 years ago, I think, and it was implemented 8 months later, which, knowing the EU and UN bureaucracy, is quite a success. So please, can you say a few words on these projects, and how do you see the future cooperation among your colleagues and with the Tribunal?
Mr. Bramertz, allow me first of all to greet everyone present here. I'm pleased to be able to discuss with you the issue that has been